Good afternoon, everyone. Welcome. My name is Tommy Vadakalel. I am a 2L here at St. Thomas. I am also a Murphy Scholar, which 1L's applications due tomorrow. So if you haven't turned it in or you're thinking of turning it in, turn it in. It's worth it, I promise. The Murphy Institute is a collaboration between the Center for Catholic Studies and the School of Law that works to engage the Catholic intellectual tradition and the practice of the legal profession together in a way that creates meaningful discussions and debate on the law and public policy through the lens of the Catholic contemporary perspective. So after Professor Carpenter's presentation, we'll be introducing here momentarily, there will be time for some Q&A. If you're looking to seek CLE credit for this presentation, there's of course the sign up right here, so make sure to grab that on your way out. You can also scan those little QR codes if you want more information about our future Murphy Scholar events. I believe our next one is in October. I'm looking to Michelle to make sure I'm getting that right. And it's going to be with Professor Gernardo, and he'll be talking about how to be a good practicing Catholic and a good lawyer as well. So it should be some interesting stuff. Hopefully we'll see you there as well. So now it's my honor, of course, to introduce our speaker, Professor Benjamin Carpenter. I had the very fortunate experience of taking his lawyering skills class, lawyering skills 1 and 2. I enjoyed it a lot. I'm still using the stuff you taught me today, which is good. I recently discovered that Professor Carpenter's first article that focused on the inheritance rights of children, not just born, but conceived after a death of a parent, was cited favorably by the Michigan Supreme Court and the Federal District Court for the Eastern District of Pennsylvania. Did not know that. And I took 2 classes with you. That's incredible. All right, so I do want to share one quick story, Professor Carpenter. I hope you know the anecdote I'm about to use right now. We'll see. So if you didn't know this, a lot of students like to shorten Professor Carpenter's name to just saying Carp. That's a common nickname that a lot of students will use when referencing Professor Carpenter. I think you knew that piece. And of course, we do oral arguments and lawyering skills too. So a phrase, if you haven't used it already, you will use it, is may it please the court. I know Professor Collette likes to make us use that during our property case debriefs. But during my oral argument, I made the error, maybe intentional error, of saying, may it please the carp. And Professor Carpenter, of course, gave me a little chuckle. He was in the middle of grading my performance. I don't think he wanted to give away too much of what he was thinking. But it was a little funny moment there, and he did promise me he would use it in his lawyering skills too anytime we talked about it. So anyone that has Professor Carpenter, gotta let me know if he pulls up the story later on and later on in time. So without further ado, Professor Carpenter.
All right, thanks, Tommy. And now that you shared that, I do remember it, and I'll always remember that one. So, well, thanks so much for coming out. It's really fun to be able to share this project that I've worked on over the past year with everybody, and to see so many students that I had the last 2 years here without mask on. It's the first time I've seen you in front of me without a mask on, so that's really great. Before I start too, I want to recognize 2 people in particular. Brina Altschuler, one of our former students who graduated last year. She was one of my research assistants on a different project and actually brought this issue to me originally. And I found it really fascinating. So I kind of owe it to Brina. She was the seed of this whole project. And she did a great job helping with it. And then as well, Nikki Catlin, our great librarian, who helped me with a lot of the research along the way. And Brooklyn. So thanks to you too. When I first heard about this, it really fascinated me because it's a topic, there's no middle ground here, right? If you've got a couple, married or not, typically it's in the cases so far, they've been married couples, all but one, but who decides, who can't have children naturally, decide to go through IVF, freeze embryos along the process, and then separate. One of the members wants the embryos to use it and the other one doesn't, right? There's no compromise here. One has to win, one has to lose, but either way, it's going to have lifelong consequences for both of the parties and the embryos itself. So that really fascinated me about that. I learned 1984 was the first time that a child was born from a cryopreserved embryo. And it wasn't too long, it was about 6 or 7 years later that the first cases started bubbling up. The first case that went to an appellate state court was in Tennessee, the Davis v. Davis case. And that was 30 years ago in 1992. So we've had now about 1/3 of the states have had this issue in front of an appellate court. So there's precedent in those states. But that Davis case, it was an extraordinary case. We'll talk more about the facts of it in a bit, but it really shaped the direction of the law in the years to come. So we're going to talk about that. As I dug into it more and more, though, what I realized is that there was more going on beneath the surface that I wasn't expecting at first. At least I viewed it that way. And I viewed it as a bigger picture of just a matter of perspective as who's making the laws and what their perspective is. And to highlight this, I'm going to start with this somewhat provocative quote that starts my article. The civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of man and woman. Man is or should be woman's protector and defender. Probably not a popular quote to start a speech off with, but maybe it got your attention. You could say, okay, well, who's this Joseph Bradley guy? You know, why should we pay attention to him? Well, Joseph Bradley was the United States Supreme Court Justice, and this was language directly from an opinion that he wrote. The opinion was whether women had the right in the state of Illinois to join the bar. They did not. They sued for the right, and the court in the 1800s held they did not have the right, and this was part of the reasoning. Okay, so with that perspective, compare that to a quote years later from a Utah Supreme Court Justice, Christine Durham. We women judges bring an individual and collective perspective to our work that cannot be achieved in a system which reflects the experience of only a part of the people whose lives it affects. Neither of these quotes were in respect to this issue, but I think they're relevant in this case. And then finally, a quote from the Venerable Benjamin Cardoza. We as judges may try to see things as objectively as we please, but we can never see them with our own, except with our own eyes. With that in mind, keep in mind, 70% of the judges who have, there's been 125 individual judges who have now ruled on this issue. 75% of them have been male, 30% have been women. The cases have overwhelmingly come out in favor of men. But in those cases, it's also been men who have overwhelmingly been seeking to prevent the use of the embryos, and the woman who has been seeking the use of it. That's probably not surprising given some basic biology, but is biology alone to explain for the difference in the way that the law developed? In these cases, the courts use language when describing the men's interests, such as no man should be forced to procreate, although they entered into this voluntarily, right? No man should face the quote anguish, quote hardships, and quote lifelong emotional and psychological repercussions of unwanted parenthood. But at the same time, completely ignoring the other party's actual interest in parenthood, right? And my thesis is that that reflects an implicit bias because the majority of the justices and judges have viewed it from a male perspective. So as I talk throughout this, keep this question in your mind. Would the law regarding embryo disposition disputes be the same today if over the past 30 years, women had had an equal voice on the bench? Okay. Okay, so with that in mind, here's what I want to cover today. First, just lay some groundwork. What is the state of IVF today and where is it trending? Then we'll talk a little more about the Davis v. Davis case, since it's the foundational case for all of this. We'll go through the judicial approaches that have developed since to addressing the issue. I'll give what I view as the evidence that there is some implicit bias that has been motivating some of this, and then talk about the approach forward, where I think the law should go. And then we'll wrap up with the Catholic perspective on it all as well. Okay. So with that in mind, what are the trends? Well, there's about 500 facilities around the country who provide IVF and cryopreservation services. Each of them has to report their information to the CDC annually, who collects it and issues an annual report. So we've got pretty good information. In 2010, there were about 150,000 IVF cycles that occurred that year. Now, the CDC defines a cycle as the beginning of the process. So the stimulation, hormonal stimulation of egg production for the purpose of retrieving eggs, or monitoring for purpose of retrieving eggs, that would be a cycle, or the thawing of existing eggs or embryos for the purpose of implantation. That's considered a cycle as well. Not on here is the year 2000. It was about 100,000 and increased 50% over the next 10 years. But over the last 10 years, it's doubled to 104 by 114%. So it's not just increasing linearly, but it's accelerating the use of cryopreservation. What may be more notable, though, is the amount, the number of women who have used fresh embryos have gone through IVF and then immediately turned around and used them for implantation or within a few days. Back 10 years ago, 2/3 of the women who did IVF did that process, had what they refer to as fresh embryos. And on the other hand, only about 1 in 5 preserved the embryos for later. And a lot of times they would do both at the same time, but only 1 in 5 or 28,000 frozen embryos occurred that year. On the other hand, the number of cycles that were begun solely for the purpose of preserving them for the future, for banking them for future use, whether that was for medical reasons or lifestyle reasons. It was only about 5%, about 7,000. 10 years later now, those have completely changed. Only 56,000 women in 2019 did IVF for the purpose of becoming pregnant presently. On the other hand, 126,000 froze embryos for future use. So the majority now are freezing it. But the real notable stat is this last one. Went from 7,000 women who did it for the purpose solely of banking to 121,000 2 years ago. That's 17 times the number of it. So what this tells us is we are really just at the tip of the iceberg of this issue. It's been a third of the states. It's going to be all the states in the next probably 10 or 15 years. And those states that have addressed it is going to come up again. So I think this is a really important time to look at this. We've got enough data now. We can look back at 30 years and see where the law was, ask why it became the way it is. And then if we think, which I do, it needs to be adjusted, we've got time to do that as well going forward. So the concrete is setting, but it's not set yet. So it's a good time to look at it. One other important stat that I'd like to share is the success rates. Now, over the years, the success rates, which means a live birth of a child, has definitely improved as the technology has improved. Women are also able to transfer single embryos with greater success than multiple embryos at one time. But big picture for women ages 35 or under, the success rate is about 43% now. For women age 41 to 42, that success rate dips all the way down to under 10%. Okay. But what's really interesting is you break that 8.7% down a little further. For those women age 41, 42, if they use fresh embryos, if they begin the IVF process over again, have to retrieve eggs and do that, the success rates drops even farther down to about 5%. So 1 in 20 chance that it'll be successful. On the other hand, if these same women are able to use the embryos that they previously froze when they were younger, the success rates goes all the way up to 36%. So about a 1 in 3 chance. So the realistic possibility that a woman in this age bracket, which is a pretty typical age bracket for the people in these cases, because they've had enough life, they've gotten married, people are getting married later, having kids later. They've tried to have kids, they couldn't, they get divorced. So by the time they get around to it, this is kind of probably a more representative age bracket. If they can use their previously frozen, they're much more successful. No court has mentioned that yet in any of their decisions at all. But the point is, it is the woman's age at the retrieval of the eggs, not at the implantation of the eggs, that really is determinative of the success rate. Okay. With that in mind, let's turn to Davis and Davis. As I mentioned, this was really a pretty extraordinary case. It was Mary Sue Davis and Junior Davis. They were married. They had tried to have children naturally for 5 years. They had 5 pregnancies during those 5 years. Each one of them ended in a tubal pregnancy. As a result of that, Mary Sue had one of her fallopian tubes removed and one ligated, could no longer conceive naturally. At that point, they tried to adopt. They tried for a year or so to adopt, but they were unable to adopt a child either through an agency. Then they turned to IVF. For 3 years, they tried IVF 6 different times. Each time she underwent the retrieval process and the hormone injections and so forth. Cost them about $35,000. It wasn't successful. At that point, she had had enough. She still wanted a child, but she wasn't willing to go through this over and over. So they paused until the technology caught up, at least in their area, where they could do it one more time and preserve extra embryos. And that's exactly what they did. Eventually, they retrieved eggs, 8 eggs, fertilized each of them, implanted 2 of them, froze the other 7, and unfortunately, the 2 that didn't work out either. 2 months after they found that out, Junior Davis divorced her. Okay. She wasn't done. She wanted the embryos. She wanted to have a child, but he wasn't sure. However, they did not have an agreement in place. They hadn't thought of this. Their advisors hadn't thought about it. So there was no agreement. They went to court over it. She asked for it. He just said he wanted to keep them frozen, not discarded, but he wasn't really sure yet whether he wanted to become a parent outside the bounds of marriage. What the trial court ruled was that the embryos were in fact human beings, and therefore she should have the opportunity to bring them to term. That decision hasn't been replicated in the years since. There have been a few judges and dissenting opinions who have taken that position, but no court has taken that position. And the Tennessee Supreme Court did not take that position. They took a middle ground and said, no, we're not willing to go that far, but we will acknowledge certainly that embryos occupy an interim category that entitles them to special respect. because of their potential for human life. By doing that, they were able to acknowledge that, but also take that off the table from their responsibility of deciding. The interesting thing, and what makes this case even more extraordinary, their positions changed at this point. Mary Sue was remarried between trial and the Supreme Court. She got remarried. She no longer wanted to have children anymore, certainly not with Junior. She now wanted those embryos to be donated to another couple who were childless. And Junior at that point decided he did in fact want them to be discarded. Okay, so what is this court to do? First, they did talk about the constitutional interest, and they recognized that under United States Supreme Court precedent, there is both a right to procreate and a right to avoid procreation. It's come up, of course, in terms of childbearing and child rearing sterilization cases, the right to pregnancy cases, contraception cases, legal parentage, who is the legal paternal and mother and father of the child with responsibilities, but it had never come up in the purely genetic parenthood case. So if you take the bodily integrity issues out of it, there's no case around the country addressing constitutional rights to embryos, purely to genetic considerations. So what the court did, since there was an agreement, they did say if there's an agreement, we'd enforce it, but there wasn't, so we have to balance the interests. But they added, we will only balance the interests prospectively. We will not look backwards at either of the parties' investments in this. Specifically, they said the trauma, including both the emotional stress and the physical discomfort to which women are subjected during IVF, is more severe than the impact to this procedure on men, obviously. In this sense, it is fair to say that women contribute more to the process than men. However, as they stand on the brink of parenthood, they must be seen as entirely equivalent gamete providers. So by taking that step, they were able to ignore everything else and just start from that point forward when balancing their respective interests. How did they define those interests? For her, they simply said it's the joys of parenthood desired. That was all the totality of the interest they gave to her. For him, they described his as the, quote, relative anguish of a lifetime of unwanted parenthood. To defend that, though, they were willing to look back at his past to say why it was so anguished. And he did have a traumatic past. This is one of the things that makes this case extraordinary. His father left the family when he was quite young. I think it was 2 or 3. His mother had a mental breakdown and was institutionalized. He was taken from the home and raised in an orphanage and separated from his siblings. So that was traumatic. And because of that, he said he didn't want a child of his being raised in a single family home. Court gave that a lot of attention. What they also said is, on top of that, Mary Sue still has a reasonable opportunity to become a parent in all of its aspects: genetic, gestational, being pregnant, bearing and rearing by IVF, or even if not, at least child rearing, raising through adoption. Completely ignoring that she had tried for a decade of her life to become pregnant, 7 different IVF attempts, was older now, and none of them had worked, but they ignored that. The court didn't stop there, though. If it had, I don't know that the law would have developed the same way, but it added in the final paragraph of the opinion in dicta what I termed the Davis presumption. It was a kind of a throwaway sentence. They said, ordinarily, the party wishing to avoid procreation should prevail. That sentence, though, has been cited by almost 18 out of the 19 cases since to help support the reasoning in that cases, even though the facts are nothing like the Davis facts. Okay. So what is the effect of Davis? As I mentioned, about 1/3 of the states, it's been 17 states. Now, for purposes of this research, I ignored trial level decisions. I only looked at appellate level decisions. One, it's hard to find them. A lot of them are just newspaper reports of a trial case. But 2, the appellate ones, it's more reliable. I felt like I had the whole universe, and they set precedent in a way that the trial cases don't. So there's been 17 states that have had appellate decisions on it. 2 states has come up twice, so there's been 19 total cases. 17 of the 19 have favored the party trying to prevent the use of it. But who was it? As I mentioned, it's overwhelmingly men. 13 times it's been the woman who sought the use. Only 2 of those 13 times has she succeeded. Only 1 time has it been the man who sought the use of it. And in that case, he already had a child, he was still fertile, and he had been convicted of spousal abuse. So that wasn't a tough call when you balance the interests. The other cases, neither party wanted to, they just disagreed about whether they should donate it or discard them. Okay, so neither one had a really true parenthood interest. So for purposes of the rest of the discussion, I really want to focus on those 13, which are much more I think, representative of the past and likely of the future, although there certainly will be cases of same-sex couples and everything else in the future that come up as well. But the principles we talk about would apply equally. Okay, so with that in mind, there have been three primary approaches that courts have taken. By far, the most common is the contractual approach. But as we'll see, they give lip service to it, but usually in half the cases, they don't actually apply it. They just say we would if it was a contract or a better contract. The contemporaneous consent approach, only 2 states have adopted that. That one says, similar to Davis, we are going to situate the decisional process at the moment of disposition, not beforehand. And the parties, regardless of any agreement, have to agree whether to use it or discard it at this moment. And until they agree, we're just going to leave it in limbo, leave it frozen, which really is just giving the party that doesn't want it a veto power, right? So it's really an unworkable solution. Only 2 states have done that. And then only 1 state, New Jersey, has explicitly adopted the balancing approach as the starting point, regardless of a contract. But as we'll see, about half the cases have decided on balancing factors. So if we look at the contractual approach, what are the pros and the cons of each? Well, the advocates for it argue that this, more than any other approach, really furthers procreative liberty. It puts the decision in the hands of the parties. It keeps it out of the government. It keeps it out of judges who may have their own views on it. And it allows them to make this decision together when they do so, when they have a contract, right? By doing it, also furthers individual autonomy by respecting the reliance that each of the parties brought to that contract. They may have had other options. They went down this path in part because of relying perhaps on the agreement that what would happen at the end. They could have done it otherwise. So this furthers the individual autonomy by respecting that. It also situates the decision-making process outside of the time of divorce earlier. They're not going to agree on anything during the divorce. Certainly nothing that usually would be the rare case, certainly something this important. So it's unrealistic to think so. And this puts it at a time when they're hopefully, there's not as much stress in the marriage. They're looking at together. They can think about it together and so forth. And if done properly, if there really is an agreement, it is easy to apply. So that helps with efficiency and so forth. The objections people say, a few people say is, look, we don't enforce contracts regarding reproduction in other contexts. So why should we enforce it in this context? But in the other context, those are contracts that require further action from one of the parties to satisfy the contract. For instance, an agreement, if I marry you, you will have 3 children, or an agreement to have an abortion or not to abortion. Those require physical conduct, which this doesn't. In these cases, the man he's performed his side of the contract by creating the embryo. There's nothing left for him to do. The only party with something to do physically is the person who wants the embryo and is willing to undertake that, right? Issues of consent, while some people say it's less stressful during IVF, others point out, but IVF is a pretty stressful time for couples as well. And to ignore that minimizes that. And those couples aren't thinking about what could go wrong. They're thinking about the decisions they need to make in the next few months as they get ready to do the process. So situating it there isn't necessarily a better approach. Also, the problem of form contracts, every single case, all 19 so far, have involved a form contract provided to the couple from the facility doing it. And it's really intended to protect the facility so that they know what to do if there is a separation. Can we get rid of these? Do we have to give it to one party or the other? So they're kind of check the box. And something this important shouldn't be left to a check the box. So a lot of people say contracts are fine as long as it's a bilateral agreement, not a facility provided form. And I think I tend to agree with that as well. We haven't seen that yet in the case law, but certainly bilateral agreements are getting more and more common as these issues are getting better known. Others point out that there's a real difference in if this is going to be a negotiated thing and leverage, because by biology, men would enter this negotiation knowing that they, most men at least, continue to create sperm for the rest of their life, would have the ability to have children post this. Whereas for the female, it might be her only, or certainly at least her best opportunity to have children if this doesn't work out. And then one objection is simply, it's easy to avoid, as we'll see in a second, if a court doesn't like the result of it. So one question that brings up is the contract approach really a guiding principle, legal principle, or is it really more of an outcome-oriented justification? And in many cases, I would say it is the latter. 7 cases so far have involved a contract that prohibited the use of the embryo. All 7 times the courts have enforced it. Okay. 3 of the cases have involved a contract that permitted the wife, the ex-wife, to use the embryo. 2 of those 3 cases, the courts found a reason not to enforce it. Okay. For instance, in Massachusetts, the court expressly said, we will enforce contracts to discard, but we will not enforce contracts that would permit a party to use the embryos. In Connecticut, similarly, the court did enforce a contract to discard, but left it open as to whether or not they would enforce a contract if it came before them, allowing one the use of it. New Jersey said, yeah, we'll enforce the contracts subject to either party's right to change their mind. So in other words, they won't enforce the contract, right? And similarly, the ABA Model Act for 2019 recommended parties enter contracts, but said that either party should have the right at any time prior to disposition to withdraw their consent from it. So again, it's kind of more of a contemporaneous consent approach. Just one quick example of a case to highlight how troublesome this can be with the contract approach. This Massachusetts case from 2000, a couple started the IVF process. They signed 7 different forms, agreements along the way that address this. Each time the couple checked the box that said, should we become separated, the wife would have rights to the embryos. When they in fact became separated and she sued to enforce that, the court said, well, the word separated is ambiguous or vague at least. And a divorce is different than a legal separation. So we're not convinced it was intended to cover that. In fact, a divorce is a changed circumstance they weren't contemplating when they signed the agreement. So we're not going to enforce it. To leave no doubt about their motivation, though, they also said, even had the couple entered into an unambiguous agreement between themselves regarding the disposition, we would not enforce it because it would compel one donor to become a parent against his or her will. We would not order a husband or a wife to do what is necessary to conceive a child or to prevent conception any more than we'd order them to do what is to make each other happy. But again, the court wouldn't have been ordering the husband to do anything at all other than to just stay back and let the wife complete the contract that they had agreed to. So that's kind of the challenges with the contractual approach. I think there is some merit to it, but even if you have it, you're going to have situations where parties don't have a contract or it really is ambiguous or vague. And in fact, in about a third of these, the parties checked the box that they would just decide later down the road, which does lend some support that this is not necessarily a great time to make these decisions either. Okay, so if we look at the balancing test then, which is really the majority approach in practice, as I mentioned earlier, only twice have courts enforced a contract to use it. But those are pretty extraordinary cases as well. In the Reber case out of Pennsylvania, the Superior Court is actually their appellate court. The woman had cancer, the couple had no children. She delayed her cancer treatments specifically to give themselves an opportunity to create embryos and freeze them for later use. Okay. Then she went underwent the treatments. She did lose the ability to have children naturally. They got divorced. By the time it got to the appellate court, the former husband had already had a child after they separated with another woman and testified that he planned to have more. Yet he sought to prevent her from using the embryos they created to have any children herself. Again, a pretty easy case, a pretty exceptional, and the court did permit her to use it. In a somewhat similar one, Savransky out of Illinois, again, the couple had no children. The woman was unable to create any more eggs. They got divorced. This was the only case of a non-married couple. It was a boyfriend and girlfriend. The boyfriend, his primary argument that he set out in court was that her use of the embryos would hinder his ability to find another partner. Okay, so the court had little trouble siding with her interests as well. But apart from that, the courts have never done that. So what are the interests that the courts have actually looked at? This is pretty interesting. So one interest that some parties have obviously raised is they have very sincere religious beliefs about the use of the embryos and they don't want them destroyed. In a Colorado case from 2019, the court amazingly said those interests aren't entitled to even consideration. Not that weight, but even consideration. But the really crazy thing about that was it wasn't because the woman's beliefs weren't sincere. It was because they were inconsistent with the way the court viewed the embryos themselves. And because that sounds almost hard to believe, I put it up here. The district court found that the wife's religious beliefs were bona fide, passionate, and predated a dispute. While the finding is supported by the record, her beliefs also were contrary to established law regarding the embryos. So basically they're replacing their views on it for the party's views. Now, this case just a few months ago on appeal got walked back a little bit, but not completely overturned. So it's a little old, but that's the stuff that has come up over the years. Other things that courts have weighed, they've looked at the woman's financial resources. One court expressly said, because we don't think she has the ability to support additional children, she should not have the right to the embryos. So effectively what they said is her exercise of her procreative right previously is now going to be used against her. And we're going to look at her financial resources. Others have looked at the children's best interests, only a few, but some have looked explicitly there. And apparently and weighted on favor of the man, and effectively saying it is better for these children to not be born than to be born to a single mother in these cases. Notwithstanding, there are about 15.8 single mothers in America today raising children, many doing just fine. Past contributions, we saw in Davis, a lot of courts say we won't look at past contributions. We're going to start at the moment of disposition, so they won't consider that. Hardships, that same Colorado court said we will consider the hardships looking forward to the parties, the hardship of unwanted parenthood, but only the hardships of the party who seeks to avoid use. We won't consider the hardships, the inability to be a parent of the other party. And again, that seems unbelievable, but here's the quote. To the extent the Supreme Court in a prior Colorado case identified hardship, it was only with respect to the spouse seeking to avoid becoming a genetic parent. Finally, some of the factors they look at as well, whether or not it was the person's only opportunity. That is the only one in those two cases we saw that actually flipped the result. But the bar for that is extremely high. There's one case where an expert said gave the woman about a 5% chance of becoming pregnant, and the court said that was a reasonable opportunity. And that's consistent with the stats we just saw, if you have to restart the process. Others have said, even if you can't do IVF yourself, you can always adopt, right? And that is true. And that's great. But for this subset of people, that was always an option for them. Maybe it wasn't an option, but it was something they could have pursued, like in Davis. They chose for their own reasons, specifically that they wanted a genetic child. And the court is replacing their views about what should be sufficient for the party's views there. So when you look at the balancing, almost every one is tilted in favor of the party seeking to avoid it. And again, that's where I say, from a bigger picture, why did it develop that way? Well, let's look a little bit at that. It could just be biology, right? I mean, it's not men's fault that they continue to create sperm for the rest of their life. It's not the court's fault that they do. And it's certainly not, but the failure or the refusal to acknowledge the differences, I think, is the fault of the courts, and to give meaning to that. So interestingly, at the trial level, women are actually much more likely to succeed. They just get reversed on appeal. 13 of the 19 cases, the woman won at trial. If those 13, I kind of identified where the woman sought to use, even of that, 7 of the 13, they won. 5 of those were reversed. What's going on there? Well, I think when you're in front of the judges and they're looking at the parties and they're hearing the testimony and they're seeing the hardships, they're looking at the equities not as much as precedent, and they're convinced by it, and they give them the right. And then when you take a step back on appeal and the appellate courts look at it from a different view and balance the interests without those parties in front of them, what I would say is their own interests, their own biases start to seep in a different way and affect the outcomes. But it's also interesting. I looked at the gender of each of the judges and how they voted. At the trial level, there have been 6 times where a woman judge first considered it. 5 of those 6, she ruled in favor of the woman client party. 16 times men judges have. It's been about 50-50 in those cases. So women are more likely to win a trial, and they're even more likely when they have a woman judge to hear it in front of them. This continues at appeal. If we look at those 13 cases, men have ruled for the woman 17% of the time. Women judges on the appellate bench have ruled 35% of the time. And if we put it all together, it's the same. They're about twice as likely as the men are to do so. Now, this shouldn't be particularly shocking to us. We've seen this in other areas as well. Employment discrimination cases that involve gender, primarily women are the plaintiffs in those cases. Studies have shown that at trial, women judges are much more likely to rule for the plaintiff than men judges are, statistically significantly more likely. And then as well, not just that, but at other studies have found that even just judicial panels that have a woman on the panel are much more likely, just the presence of that woman on the panel to maybe swing the outcome in a statistically significantly different way. And then a more recent study that was looking at a broader set of cases in which gender was a kind of a guiding issue, found that even judges that had a daughter were statistically significantly more likely to rule in favor of the female party than judges that did not have a daughter. So that this might be creeping in here shouldn't be particularly shocking. One other piece of information that I found very interesting as I discovered it was there have been 8 state Supreme Court cases now that have addressed this. 15 of those justices have been women, 54 have been men, or 15 of the 54, so about 25%. But the women have been assigned to write 5 of the 6 opinions in which the woman sought to use it. Okay. Only once did the woman get the right to, but nonetheless, so in all of those, almost every time they've assigned it to one of the women judges to write it. In 3 of those 5, there was the only woman on the bench. So there were 6 other options, and almost every time it went to the woman. And in fact, in the only case where the Supreme Court awarded the embryo to the woman, it was a 4-3 decision with 3 women judges, all 3 in the majority, and 3 of the 4 men in the minority. How is this relevant? Well, I think it suggests at least that there is a subconscious understanding that there's some gender issues going on here, and by assigning it to a woman to write an opinion against another woman, it might help the optics a little bit and lend some legitimacy to it. So that's just a theory, but the numbers are, I don't know if they're statistically significant, but they're compelling enough when you just look at them on their face. Okay. Oh, when you look at it all together, all appellate panels at all levels, women constitute less than 1/3 of the judges, but have written over 2/3 of these opinions. Now, if you take a step back and you put this in the context of reproduction and new technologies over the years, you see this standard too. I address this much more in my paper. I'm not going to address it too much, but just real quick, 3 data points. There was the coverture doctrine way back under common law, where women were considered private property of their husbands and had no rights in the children of the marriage. That's no longer the case. It has been for a long time, but that was there. There was the old marital presumption where any child born to a marriage was deemed to be a child of the marriage, and women were not even permitted under evidentiary rules from testifying otherwise. Part of the reason for that, part was the best interest of the children, but part was to, many scholars think at least, so that the husbands didn't have to bear the indignity of seeing their woman on the stage, or seeing their wife on the stage speak to her infidelity and his lack of control over her. That marital presumption has seeped into these new laws as assisted reproduction has been applied under the original Uniform Parentage Act. If a married couple used a sperm donor because the male was infertile, the husband only needed to consent to the use of it to be deemed upon birth the husband. On the other hand, if it was the woman who was infertile and they needed to use an egg donor, she needed to adopt the child after the birth herself. That's no longer the case, but that was the initial position in the 70s as well. So I expand on that more in the article, but just as a data point there. So how should we then, with that in mind, look forward and reweigh the interest when these cases come up? Well, the courts really look at it in 3 ways, 3 different aspects or a bundle of sticks of parenthood: gestational parenthood, pregnancy and all that goes along with it; legal parenthood, the requirements and obligations after the child is born; and then genetic parenthood, just having a biological connection to that child. Each of these can also be further broken down then into the right to be a gestational parent or a legal parent, or the right not to be a gestational parent. Obviously, men have no interest in gestational parenthood in these cases. They don't have no direct interest in it. They cannot gestate a child. But what courts have done is said, because men don't have an interest, they've completely ignored any interest that a woman had. And what it's actually said, they turned it on its head and said, because we can't force a woman to be a gestational parent, we can't also force a man to be a genetic parent. But those are not equivalent things at all, right? And so that's one interesting thing that's gone on. And so they've used the lack of interest in the man to then ignore any interest that the woman might have had as well. And I think part of that is discounting the experience of pregnancy in the first place. Certainly not all women want to become pregnant, want to have children, but for many people, many they do. And for many, the experience of pregnancy, while not all beautiful in roses is something that they really want and cherish. And this is a subset of women who are fighting for that opportunity. So to not accord any weight to it seems to be disconnected from reality. It also, I think, applies a traditional view towards marriage and procreation that's just not present in these IVF cases. Traditionally, the act of becoming pregnant is sex, generally a pleasurable experience, not always, but generally for both couples. For IVF, it's very, very different. It's a painful, it's an expensive, it's an emotional process. So I think if you asked the majority of women who went through IVF when their pregnancy started, it wouldn't be upon implantation. It would probably, they would view it as the whole process to get there. And in fact, I've got a quote from one of the recent cases to kind of a window into that. This is what the female party said. The fertility process was absolutely horrible. I gave up my career, I gave up my time, I gave up my health, and I worked so hard at it. I went to every single appointment. He didn't go to the appointments. There were times I was there 3 times a day and I'd go home and take him the cup. So he would give me a sample and I'd come back. I sacrificed so much of my life and my time for this child. So to ignore that commitment and those investments that a party made and say, we can't consider that, we have to start at the moment disposition, I think is a change that needs to occur in the way that the courts view the law. The other aspect then, legal parenthood, is an interesting one because courts often say, we don't want to put on the man the financial and emotional responsibilities of legal parenthood. But no court has ever found in this case that a man is actually responsible. In fact, most courts have found the opposite. When it's gotten to that, the man would not be responsible for it. There are model rules now that say that the men won't be responsible for it as well. So this saying that they don't want to do it is kind of a red herring because it's never been done in the first place. But by doing it, they say, so we're not going to even consider it. At the same time, women or either party, whichever wants to use the embryo, does have a real interest in legal parenthood. I mean, being responsible for somebody, raising somebody, that's a central part of a lot of people's lives. And so that process to, again, just ignore that altogether, ignores the reality of these cases and does a disservice to the women. It also treats legal parenthood in primarily financial terms, as though the biggest thing about parenthood is the cost that it'll be to the man, ignoring that, but the woman is going to be doing this on her own and willing to incur those costs as well. But it's much more obviously than just a financial transaction. So the ABA family law section with respect to this particular thing way back in 1997 said the relinquishment of parental rights and responsibilities of the party who opposes bringing the embryo to term does not involve concepts fundamentally different than those underlying single parent adoption, single parenthood by artificial insemination, and state laws governing artificial insemination, all of which protect the party from legal parenthood. This issue, they concluded, should not be a difficult one. Yet some courts treat it as though it would be if they considered it, but they're not going to consider it. So then that leaves us finally with genetic parenthood. And what really are the interests here? Well, Glenn Cohen from Harvard has written a lot about this, some really interesting articles. And he points out it's not really that there's a person out there with my genes that's the harm here, or the potential harm. It's the attributional aspects of what that means. And he cites 3 different attributional aspects. One is those expectations that society puts on you if you're an absent parent and you shouldn't be. It's the expectations that that child may put on you down the road when they think you should have been a parent or unhappy, both of which are real and concerns. But he says the most important one is just simply the guilt that a person feels by being an absent parent and knowing their child is out there and they're not a part of that child's life. So those are certainly important. The New York Court of Appeals, for instance, said a woman's mere discomfort, expenses, or other potentially surmountable difficulties of having to go through IVF again should not suffice to defeat the fundamental right to avoid biological fatherhood. So they treat the concept that you would have a child out there as basically an insurmountable anguish for these men. Again, notwithstanding that there are millions of men in America today who are absent parents and they're doing just fine. On the other hand, the ABA again said, well, look, IVF itself was an elective process. And in fact, it's much more deliberate and considered act than the act of sex. It should not be difficult concept to consider that under these circumstances, the individual's right not to procreate or not to be a parent is extinguished at the moment the embryo is created. Okay. So as we reweigh those interests, I would encourage courts going forward to first recognize the women's interest in the process that they went through to become a parent retroactively, and in their interest in simply being pregnant itself, right? Just because men can't experience that doesn't mean women have no interest in experiencing it. Two, the court should assign at least some weight to the hardship, the physical, emotional, and financial that's required of the woman if she is going to be required to restart the IVF process, and not treat that as just her responsibility. Two, respect the physical, emotional, and financial investments of the party, man or woman, who is actually willing to invest themselves in this child and raise the child and all that that means. And then finally, recognize there are interests in being a genetic parent itself, in raising, supporting, and shaping a child in your own likeness, and passing along genetic and familial heritage, experiencing the bonds that are unique to a parent-child relationship, and in fully achieving your own sense of personhood. Yes, we can't quantify those, just like we can't quantify the interest in not being one, but it doesn't mean they're not real interests that should be given at least some weight. So my ultimate thesis here would be simply, in the past, courts have privileged men's interest in avoiding what I would say the purely cognitive inconvenience of unwanted genetic parenthood, even when freed from any legal responsibilities, while minimizing women's interest in experiencing parenthood in all of its aspects. In the future, the law should favor the party, whichever sex or gender it may be, who is actually committed to making the mental, physical, emotional, and financial investments of raising the child over the interests of the one who is merely seeking to prevent that life from occurring in the first place. Okay. So to tie it back to my matter of perspective, in a fairly recent U.S. Supreme Court case, not about this again, but the court noted the decision to choose a rule in that case, it was an adoption case, that systematically preferred men could be explained only as the product of habit rather than analysis or reflection. And I would say that kind of is what has happened over the 30 years here as well, and challenge the courts to consider their analysis and reflect on what might be driving their decision beneath the surface. And to wrap this piece up, at least with a Minnesota connection, former Supreme Court Justice Rosalie Wall said, "My experience is that the presence of one woman alone on the court, one person of color, one differently abled person, heightens awareness, broadens perspective, and begins to change the direction in some way." But she added, numbers do make a difference. Right. Okay. So quickly, I want to talk about the Catholic perspective. I apologize, we've only got 5 minutes left. I will be happy to answer any questions afterwards if you do. But just quickly, what is the Catholic perspective on it? Well, the Catholic perspective still is against IVF. It's still not permitted within the church or endorsed within the church. It goes back to, I think, the first, at least significant expression of this was in 1987 in the Instruction Dominum Vitae. Certainly one can not ignore the legitimate aspirations of sterile couples. It is asked, though, whether when there is no other way of overcoming the sterility, which is a source of suffering, in vitro fertilization could be admitted, but this good intention is not sufficient for making a positive moral evaluation of in vitro fertilization between spouses. I'm sorry, I'm reading a lot, but I just want to get the actual language because I'm not an expert here. Even in a situation in which every precaution were taken to avoid the death of human embryos, IVF disassociates the conjugal act from the actions which were directed to human fertilization. Essentially, the church's position still, the act of having sex itself within the marriage is an essential part of the process. IVF separates that, and so it's outside the church doctrine at this point, and it has been and will likely be going forward. With respect to frozen embryos, though, so that's the position. What about couples, Catholic or not, who go ahead and do it and now have these embryos? Well, the most recent expression of that was the instruction from the Congregation of Doctrine of Faith, Dignitas Persona, which said the Catholic teaching excludes the use of abandoned embryos for medical purposes, which probably isn't a surprise, thawing of frozen embryos, which wasn't, and donating them to infertile couples, which did surprise me when I first saw it, but it ties back to the importance of the conjugal act under church doctrine as well. But the court recognized nonetheless, or not the court, the church, all things considered, it needs to be recognized that thousands of abandoned embryos represent a situation of injustice which cannot be resolved. There's no easy solution to this, right? None of those options work. The only option would be though if the woman uses it. But over time and for many reasons, that's just not going to happen. So what do we do? Well, one last quote from Pope John Paul. When earlier times he addressed it, there seems to be no morally illicit solution regarding the destiny which of thousands of frozen embryos, which are and remain the subject of essential rights and should therefore be protected as human persons. So what I hope that I've done with this small little sliver is found an area where I do think there's actually a real merging of interest between people who would associate as pro-life, pro-choice, pro-life and pro-choice. I think by considering what's actually going on, giving the respect to the women's interests that they haven't been given so far, it increases procreative liberty among women. And at the same time, it also serves the interests of pro-life by supporting the embryos as well. So, okay, I've got 2 minutes for questions. Anybody want to start? Yeah. Oh, it's on SSRN, the social, whatever it is, network. Social Science Research Network. Very good. If you also just email me directly, I'd send you a link to it, sir. Thanks.
It's being published in the Yale Journal. What's the journal called?
Yale Journal of Law and Feminism.
Law and Feminism.
Yeah. So it should be out in about a month or two, but I can get you the draft for now. So, yeah, Gabriel.
Answer like general in the country. Women are more willing to freeze embryos.
I don't know. I haven't seen, I wasn't looking at that, but as I was reading different things, I never saw anything to support that. But I wasn't focused on that, so I really don't know. Yeah.
A lot about IVF, but is one of the reasons for not allowing embryos to stay with a woman with a better option with a just research that it's not a combined embryo that has another person's interest?
Right.
Or is it because they were, the only time she had thought about it was when she was in a marriage and something pretty embryos and not as an option?
Yeah, so that wasn't really a viable option until fairly recently. The technology, the likelihood of a live birth was much greater with a frozen embryo than with a frozen egg or oocyte. That is becoming closer. The technology is getting better and women are able to freeze it. From a Catholic perspective, they don't make a distinction between the two. It's still an artificial process. But as far as giving women the choice along the process, that would help that. And one of the points I make in the article is the courts treat it as though this is the man's DNA. They ignore that the woman put her DNA and they voluntarily merged it too. So why does she not have an equivalent or vice versa? Again, this is the context that typically comes up, but I think it would apply whichever party seeks to use it. Good. Yeah, Michaela.
I don't know how serious this is, but I read an article talking about like the Tennessee proposed law banning abortion that would criminalize discarding embryos. Do you think that legislation like that can impact?
Well, that's a great question. And my understanding is I don't think it directly would, because from what I've read, most facilities, when the embryos are abandoned, when the couple stops paying the storage fees, when they can't locate them, they still are hesitant to discard them themselves. They keep to store them because they're afraid of a lawsuit or something. So the consequence of that law might be that the facilities just keep storing and storing indefinitely, potentially even past the point that it would be viable. We don't really know what that point is yet with science. The oldest an embryo has been frozen and then used successfully has been 24 years. It was in 2017 or 18. So that wouldn't really resolve the issue. It would maybe prevent the thawing and discarding of them, but it wouldn't increase the use of them. So it's good. All right, I know you guys have class. Thank you very much for coming. I'd be happy to talk to anyone else if you want outside of this, and have a great day.